of anyone who we are going to, or I guess the association will present an affidavit in support of the response to the motion. With new counsel coming in, this is going to take some time. I'll let Mr. Souter discuss a little bit more the response to the motion and what's going to be necessary for the response. But this is a very, very big motion seeking to take control away from the association on this condominium tower. And it's going to need some time to get everybody lined up, get everybody deposed who needs to be deposed, get all the affidavits in place, and then have a hearing on this motion to appoint a receiver. Right now, the judge, you've ordered us to conduct these depositions by October 22nd. We haven't even been able to get our entire file over to new counsel. There's literally 6,000 emails that we are having to download, numerous pleadings, over 4,000 documents. This will take some time. There's nothing that is emergent right now. There's no emergency. There's no need to push to have this motion to appoint a receiver heard within the next 2 weeks. So what we would ask is that the court allow at least 30 days for new counsel to get in, to start interviewing the clients, review the documents, review the relief that Mr. Payne and Ms. Alstron are proposing, have discussions with counsel, and then schedule what needs to be scheduled so you can have a meaningful hearing on this motion, because this is a very important motion. And the time needs to be devoted to getting the response prepared in opposition to the motion. And again, I'll let Mr. Souter discuss a little bit on the scheduling related to moving forward, because he'll be stepping in as counsel for the association.
Okay, go ahead.
Good morning, Your Honor. Jim Souter. Your Honor, we just made an appearance on Wednesday. I've been trying to get sort of understanding of the allegations and so forth and what's going on in the lawsuit. I understand it was filed in 2019. I understand that this case needs to be moved forward and that things need to be accomplished. The gravity of this motion to appoint a receiver is rather significant. This is a 300-unit owner high-rise condominium unit. It has 9 board members duly elected by the association. What's being requested here is to essentially take over all those activities, from my perhaps even assessment collection, paying the bills, everything else, when that is not an issue here. The issue is simply the plaintiffs want to have some activity, some action with respect to fixing, if you will, repairing or replacing the roof, which has caused some roof ceiling damage and other damage, perhaps to Mr. Jackson's roof unit. There really is no urgency to having this motion to appoint receiver, but considering the gravity of what's being requested here and what the plaintiffs want here, Mr. Jackson wants, this is a very serious situation with respect to the request that's being asked for. So I do not have all the documents. Mr. Payne reached out to me day before yesterday, and then he and I spoke. We agreed to sort of work together on some of these scheduling issues. One of the things that I did mention to him that I noted that neither the plaintiff or the defendant's depositions have been taken. We have a December 7th trial setting. I don't know how realistic that is. I think we need to have a new trial setting. And and Mr. Payne doesn't want to push it out 6 to 9 months. I understand that. We can work on that, perhaps March or April for a trial setting to allow the parties to take those depositions. But I would like some time to be able to get together and try to work on this in a meaningful way. So if I could have some time to do that, perhaps mid-December for a hearing on the motion to appoint receiver for this very serious matter. So, and I wish I knew all of the facts of this case. I do not know all the facts of this case. I do not know all the background. I still don't have the file yet, and I'll do my best to prep up, but I understand we do need to move this docket and get it going.
Response?
Yes, Your Honor. I think we need to step back a little bit here and take a look at the history of this case. This case is over 2 years old. The plaintiff's original petition was filed on August 28, 2019. It's not a liability case, Your Honor. This is a damage case. The fact of the matter is they have liability. They're responsible for maintaining the building and all common areas. We have proof that over the course of the last 10 to 15 years, they have made conscious decisions not to maintain the roof. And in fact, they have in hand reports which demonstrate that the roof needed to be replaced back in 2018. They consciously ignored that report, chose to create a situation which exacerbated the problem. The roof on this building, Your Honor, is
Okay, you're really arguing the merits here. I'm familiar with this case. We've had a ton of hearings in it. Let's just talk about logistics. Are you opposed to the continuance? You're not opposed to continuance? What is your position? I'm
opposed to the continuance. This is the fourth and fifth set of counsel that have come in on this case. It's odd that it happens just before we're getting ready for trial and just before we're going to have this hearing. Now, I'm willing to work with counsel. I've worked with Mr. Souter in the past, and we've successfully resolved cases. I have not worked with Mr. Ciolos' firm, but I'm willing to. The problem that I have is yesterday in the conversation, Mr. Souter explained that he's set for trial next week or the week after in federal court. That's the week we would have been taking the depositions. I'm willing to work with moving the hearing, but Judge, I don't want to postpone a couple of months. I don't think it's appropriate that it be moved a couple of months.
What do you think would be appropriate?
If we could move it 2 to 3 weeks, and look, I'm not trying to be unreasonable, but Mr. Souter's firm is 200 plus lawyers in 5 or 6 different cities across 3 states. Mr. Ciolos' firm is some 30 lawyers. Between those 2 firms, they can find someone who can attend and participate in depositions. We're 3 lawyers, and we'll accommodate what we need to get the depositions done. We asked for specific individuals, and we've not gotten a response back. And so, Judge, again, I recognize if there's a conflict, it's going to take some time, and I'm willing to work with them and be reasonable. The court could probably give us some instruction with respect to whether or not it's realistic to think that we're going to go to trial the first week in December.
May I?
Sure.
Thank you, sir. I'm obviously in the same situation as Mr. Souter. I don't know that I have the file material, certainly not all the file materials yet. And ICI, as I understand it, is not directly impacted by the motion to compel that's on the court's docket for today for the inspection, or the motion to appoint a receiver. But I'm not opposed to the relief that Mr. Souter is seeking on behalf of the association. And given that apparently there are new allegations, causes of action, new elements and theories of damages arising out of August of this year, that's going to require probably discovery and additional investigation above and beyond what's happened in this case over the past 2+ years. So to the extent that there's a request by the association for a continuance of not only the hearing on the motion to appoint a receiver and the trial setting, we're not opposed to the receiver hearing being moved back, and we certainly would join in the motion for continuance, because I'm going to need some time just to get up to speed. And maybe Mr. Souter has a lot of attorneys in his firm, and we have 30 or so in ours, but not everybody does these kind of cases, and not everybody's a partner. Not everybody has enough experience to handle and try these cases. So that's kind of disingenuous. So if Mr. Souter's counsel and I'm counsel, I think it's reasonable for us to have a reasonable amount of time to get up to speed on this case in light of new allegations and new theories of damages.
Mr. Johnson, is it correct that this is the 4th set of counsel in the case?
This would be the 3rd set of counsel. The first counsel in the case was Bob McGee over at Mike Bassett's firm. He was counsel for, I believe, a year. Then Mr. Jackson began sending emails alleging that he was going to sue Mr. McGee and the Bassett firm directly. which precipitated Mr. McGee's withdrawal. And we joined the case in August of last year. Again, Your Honor, we worked with Ms. Alstrom, we worked with Mr. Payne, trying to resolve this case. We mediated in April. We weren't able to get it resolved. We've talked about depositions. We need to do some document supplementation. And then going to what Mr. Scioto said about this new claim of damages, which is in the most recent petition. In August of this year, Mr. Jackson reported another water intrusion in his unit. We sent out our expert, plaintiffs had their experts there, middle of September, and they discovered that it appears, at least it's possible, that this water intrusion event isn't related to the roof, but instead is related to his HVAC unit. I've been consulting with Ms. Alstrom. I've got emails from Ms. Alstrom saying that we still need to determine the source of this leak, whether it's the HVAC or whether it's the roof. They had an expert go up onto the roof last month. We still don't even know who that expert is. That expert hasn't been identified in discovery. So to go to what Mr. Scioto said, this is an ongoing situation. There's a new management company in place who is doing work on the roof, who is going out, trying to get financing to get a roof replacement done, who we will be producing reports. We don't have all of them yet, which is why they haven't been produced. But there's a lot of work still ongoing, especially with a new management company in place, Worth Ross, that's going on with this roof. That's going to require additional discovery in order to get this case ready for trial. So yes, Your Honor, while this new counsel will be the third counsel for the association and ICI, that's
okay. All right. So this is what I'm going to do for the receivership motion. I'm going to set this on November 8th. So that should give you guys, let's see, a little over 3 weeks to get that taken care of. That should allow you to get up to speed. We'll set that for 8 o'clock. I'm sorry, not 8 o'clock, 4 p.m. And then the trial setting, I think at this point, you guys don't know enough about the case. And so I think it's unlikely you get reached in December, but why don't you guys kind of figure out, once you're a little more into it, if there's a continuance really needed. It probably is, but I'm not going to rule on that yet. I will grant the motion to compel. I will grant the motion to withdraw as well.
Your Honor, briefly on the motion to compel, Your Honor, they are seeking to compel entry on non-parties' private residences that the association does not have the right to enter without permission.
I'll allow there to be any type of inspection on, I agree, anybody into a private residence, those people would need to be notified of this hearing. So to the extent that it goes and requires you to go into private residences, those people need to be notified of this hearing and a right to object. So I'm not going to allow that. You're right about that, but I am going to allow the inspection of common areas.
Your Honor, the covenants, conditions, restrictions permit them to enter into every residence for purposes of inspection and corrections and repairs and maintenance. It's a specific clause in the covenant.
It allows them to do that, though. It doesn't allow you to do that.
Right.
That's correct, Your Honor. We're asking them to go ahead and obtain entry for us so that our expert can do that.
If you want that relief, then you need to identify the folks that are involved, and then they need to be notified of the right to object.
Understood, Your Honor.
Okay. So go ahead and get me an order on all of this, all of these rulings, and we're going to go ahead and have to let you guys go. So thank you so much. I know we have a number of hearings set. I need to take a quick break. Oh, good. Okay. So we'll be back. You guys are excused. Get me an order.
Thank you, Judge.
Yes.
Okay, we have the minor prove up next.
Morning, Judge.
Good morning.
Morning, Judge.
Morning, guys. Sorry, it's a bit of a busy morning. So we're going to go ahead and get started with this.
Judge, we have one preliminary matter on this. We are 99.9% ready on this. We had one tiny issue of the defendant being available to provide us with an affidavit of no other insurance or assets, because this is a 30,000 policy limit case.
I knew it.
And we have made some significant efforts to reach her, but have not been able to get the affidavit, nor is she appearing now. So one idea, and we defer to the court, but one idea was to prove up everything we have and then stalk her, literally, to get that affidavit on file, and then we submit the judgment to you for entry and approval.
So I would not sign the judgment today.
You would not, only because that's the last piece of evidence that I think is critical to the record for your honor to be able to say you're going to.
Sure. That makes perfect sense. How does everyone else feel about that?
Defendant's okay with it, Your Honor.
I'm sorry?
Defendant has no problem with it, Your Honor.
Okay.
Plaintiff has no objection.
Okay, so let's get started on this. And so I'll just put a note in the file. How quickly, because right now, let me just check this. Is this case on a DWAP or what is it?
We've been trying for some time, Judge. I made the request probably at least 30 days ago, and there's a unique situation here where the defendant is now the ex-girlfriend of the family member of the plaintiffs. So we've been trying to catch her. She has been responsive. She's just not here today, and we don't have the affidavit. So I think it's everyone's collective hunch that we will be successful in getting the affidavit from her. If not, we'll come back to you and let you know.
Okay. So we'll put this on, let's say, a 60-day DWAP. And I'll put a note in the file that indicates that we're just waiting on this affidavit. And then after this is, assuming I approve this up, assuming that I approve this, then go ahead and contact the court, Ms. Armstrong, once we get all that done, and let us know that we need to go ahead and sign the judgment and your request for attorney's fees.
Happy to do it, Judge. Happy to do it.
All right, let's go on the record on cause number DC 211897. Mansoura Music versus Stephanie Wood. Counsel, make your appearances.
Christopher Bryan, attorney for the plaintiff.
Nick Palmerozzi for defendant Stephanie Wood.
Melody Armstrong, guardian ad litem for minor plaintiff M. And Judge, we also have Miss Rebecca Reedy Miller, who's our structured settlement broker, as well as our minor plaintiff, Miss M. with her mom, Mansoura Music. I think they are on.
Okay. All right. Let's get started.
Mr. Pride?
I would like to call Mansoura Music as a witness.
All right, ma'am, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, let's proceed.
Okay. Ms. Mansoura, please state your name for the record, spelling your last name.
Mansoura Music, M-U-S-I-C.
Are you the natural mother of Melissa Music?
Yes.
Do you have the ability to make legal decisions on behalf of Melissa Music?
Yes.
Do you understand we are here today because of an incident that occurred on November 2nd, 2019, where Melissa Music was injured in an auto accident?
Yes.
At that time, Melissa Music was a passenger in a vehicle driven by Stephanie Wood, correct? And Ms. Wood was driving her own vehicle at the time and rear-ended another vehicle, correct?
Yes.
Was Melissa Music injured in that accident?
Yes.
She experienced pain to her neck, chest, back, and midsection, correct?
Yes.
As a result of her pain, Melissa treated with Dr. Brian Starry, a chiropractor, correct?
Yes, sir.
And you incurred a total of about $22,647.50 in medical bills on behalf of Melissa Music, of which
Yes.
$2,801 is due to pay outstanding medical bills and the Medicaid lien. Is that correct?
Yes.
Melissa Music has not treated since December 20th of 2019, correct?
Yes.
And you understand we are here today because we're asking the court to approve a settlement that has been reached. Is that right?
Yes.
The total amount of the settlement will be $30,000, correct?
Yes.
And out of that settlement, $2,168 is being paid for outstanding medical bills, and $633 is being paid to reimburse Medicaid. Is that right?
Yes.
You understand that you hired this firm to represent you on this claim, correct?
Correct.
And at that time, you agreed to a contract fee of 1/3 plus expenses.
Yes.
You understand that $10,000 of attorney's fees plus $499.93 of expenses will be paid to our firm, correct?
Yes.
And you believe this is fair, right?
Yes.
After paying the medical bills and attorney's fees and case expenses, the remaining money of $16,000 or $16,699.07 will be placed into a structured settlement. You understand that you cannot have the money. It will be held in your daughter's account until she turns 18, right?
Yes.
You understand that you do have a right to a trial by jury, and a jury may award her more, less, or nothing, correct?
Yes.
And do you believe that this settlement is in your daughter's best interest? And are you asking the court to approve this settlement as outlined?
Yes, sir.
Okay, pass the witness.
Any other
No
question?
No questions, Your Honor.
Ms. Armstrong?
May I proceed, Your Honor?
You may.
Ms. Mansoura and Ms. MM, good morning. How are you all?
Good morning.
Good to see you again. Judge, I would like to refer the court also to the guardian ad litem report, which is on file and has been file marked for any references of additional details the court may require.
Okay.
Ms. Mansoura, the vehicle that the defendant was driving was actually a vehicle owned by you and your husband, a 94 Honda Accord, correct?
Correct.
And so as a result of this crash, your daughter unfortunately presented to EMS 2 days after the crash, November 4th, 2019. And after examination and diagnosis, she suffered 2 fractured ribs, the 7th and 8th rib on the left side of her body, correct?
Yes.
As a result of this crash, she also had quite a bit of post-traumatic stress, a lot of anxiety, a lot of fear when she's in vehicles, sitting in the passenger seat, and just even being in cars for quite some time, correct?
Yes, ma'am.
And as a result, during our couple of video visits last week, as well as last month, when I examined MM, we talked about how she may still have additional future damages and needs for counseling and treatment for that stress because of this crash, correct?
Yes.
So you also understand why we have taken some time, all the attorneys and I, to try to get the affidavit from Ms. Wood, because we need to confirm for you and your family that there are no additional financial resources to compensate your daughter for the injuries, the physical and the emotional that she's suffered. Is that correct?
Yes.
You understand that once the settlement is approved by Judge Hoffman, you won't be able to sue Ms. Wood anymore. You understand that?
Yes, ma'am.
You also understand that I asked Mr. Pride and his team to provide a report of a public data search to determine if there were any assets in public records that Ms. Wood might have. You understand that?
Yes.
And Mr. Pride provided that report to me, and I will attest to you that it didn't appear that she has any additional assets other than a Nissan vehicle. Do you understand that?
Yes.
As it relates to how your daughter's doing today, she's in the 8th grade and her grades are pretty good.
Yes, they are.
And she had a well child visit recently and was cleared for some sports. Is that correct?
Yes.
You understand that we've had an opportunity to visit with Miss Rebecca Reedy Miller and Sage Settlement Group for structured settlements. You understand that?
Yes.
We talked about the net amount of $16,699.07 not going to the registry of the court and instead being invested into a structured settlement plan. Is that correct?
Yes.
You understand that the insurance company is Pacific Life and you are going to get a contract fully signed by you and someone at Pacific Life that you do need to keep in a safe place.
Yes.
You understand the amounts on this structured settlement are going to be fixed. They cannot change, and the amounts are going to be paid on the dates designated. You understand that?
Yes.
Any questions about that?
No, ma'am.
You also understand that Pacific Life had to meet certain financial ratings on Wall Street, and Ms. Reedy's affidavit is on file to attest to that. You understand that?
Yes.
Judge, I do offer Garden Ad Litem Exhibit 1, which is the affidavit of Rebecca Reedy Miller. It has been e-filed and e-served and tendered to all counsel.
Have you sent that to Tony?
Tony.
Tony, my court reporter.
No, sir. I just e-filed it. I can email it to Tony if you would like.
Yeah, Tony, do you mind putting your email? Yeah, under the just so you know, under the emergency order of the district courts, civil district judges, you're supposed to just provide any exhibits to the court reporter the day before the hearing, just FYI. So if you can just get that, just email it to her.
I will do that. Okay.
Unless, well, have you filed it with the court too?
Yes, it is. It's been accepted already.
You want me to just, would it be easier for me to just take judicial notice of it?
That would be great if you don't mind.
Okay, so we're not admitting into evidence. We're just taking judicial notice once in the clerk's file.
Okay. Miss, may I proceed, Your Honor?
You may.
Ms. Music, you understand that if there are any additional medical needs resulting from this particular crash, that those are going to be the responsibility of you and your husband on behalf of your daughter. Do you understand that?
Yes.
You also understand that you're going to continue to love and provide for her as if these funds do not exist, right?
Yes, ma'am.
And you're going to make sure that when she turns age 18 and she's able to change her beneficiary, that she does not put some little boy's name on there because he told her she was beautiful, which she is. But make sure she doesn't do that, right?
Yes.
All right. Do you have any questions for me or for Judge Hoffman about any portion of this settlement? Because it is important to the judge that you understand everything that's happening.
No questions.
Okay. You are asking Judge Hoffman to approve this settlement freely and voluntarily?
Yes, ma'am.
And that is because you believe that it is in the best interest of your daughter. She is healed as best as you can tell at this point, aside from occasional stressors and anxiety in vehicles. Otherwise, she's okay?
Yes.
Pass the witness, Your Honor.
Ms. Music, do you have any, or your daughter, do either of you have any questions for me?
No, sir. Oh.
I do have a question for Ms. Miller. I'm glad you're here, Ms. Miller. So I have not had this come up before, so I want to make sure we're not causing any problems. Since we're not, I guess, signing the judgment today, is that going to interfere with our ability to get whatever rate we have for the annuity, or how is that going to work?
Yes, Judge. So it could, should the rates change, but I'll keep Ms. Armstrong up on that. We actually have a funding date that's not till December 11th. So we're almost at 60 days.
Okay. All right. So you should, as long as we fund it by December 11th, we should be okay.
Yes, sir. And if we do need to get a few days extension, 5 to 7 days, I'll be able to do that as well if we don't receive anything before 60 days.
Okay. We're on to make sure to put this on a 60-day dismissal docket. All right, other than obviously the affidavit, assuming that there's no other assets, what is the recommendation of the guardian ad litem?
Your Honor, the guardian ad litem recommends that the settlement be approved in the amount of $30,000, which is the policy limits from the policy on the vehicle, and that it be allocated and distributed in the amounts before you. Did we, Mr. Palmarosi, did we send him anything?
We did. Yeah, we
Okay.
did. There was an error getting it uploaded in e-file, but I believe it was emailed.
It's in the system now. I've looked at it.
Okay.
Just double check it. Yeah, there was the report of the guardian ad litem, and the judgment was filed today, I guess. So, yeah, just the main concern I have is I want to get this funded so we don't, any delays aren't going to cause us to get a worse deal for the minor.
In your honor, if we get within a few weeks of the funding date, I don't have a problem even sending the check to get it funded, and then we can always, back the money out.
All right, let me look at something real quick. It looks, yeah, everything looks in order. I'm just taking one last look. So is there 3 lump sum payments? Is that the deal?
That is, Judge. We obviously didn't want to put 16 and some change into the registry of the court for her, and we needed to make sure that we returned the principal. So Ms. Miller, Reedy Miller, and her team came up with illustrations that would at least return principal and allow her to earn some cash. And when I ran the illustrations for a CD that might have been in the registry of the court, she might have earned about $200. So
Yeah.
I think we are in the best interest by doing the structure. She's going to earn a little bit more money, and we'll stagger the payments to her so that as she matures with money, she will have more money as she's growing.
Okay. All righty. Well, the court will go ahead and approve the settlement, and thank you again for your service, Ms. Armstrong. Is there an agreement as to the amount of the guardian ad litem fees?
There is,
Yes.
Your Honor. We're in agreement.
What is that amount?
It is, I think, $43.78.50, Judge, and there is a guardian ad litem order on file as well, and the amount should be included in that judgment.
Do I sign that now, or do I wait until everything else is done?
I would be happy if you sign that separate order now.
Mr. Palmarosi, it's what do you think?
And Nick, I won't bill you for anything else I have to do to stop the defendant. So if you agree now, then you're good later.
Yeah, no, that's fine with me. That's fine with me, Your Honor.
Did you, I don't see the order on that. Have you already submitted that?
Yes, sir. That was accepted as well.
Let me share screen. I don't see it. Maybe I'm missing it.
Oh, actually, you don't have it, Judge. I think my affidavit was accepted. I'll submit one.
Okay.
I'll
All right.
submit
Yeah.
one.
You might want to just follow up with Rhonda to make sure that it gets to my queue and everything.
Okay.
So, did you email me the order? Let me see.
I have not. I can.
No, I do have the judgment. I still don't have the order now. Okay. So yeah, just get me that and send it to Rhonda. Make sure that she knows to forward it to me. You probably want to e-file it as well, and we'll get that signed as soon as possible. Mr. Armstrong, thank you again for your service. I will approve the settlement contingent upon the receipt of that affidavit. And if we don't get the affidavit, I guess we may need to have another hearing just to talk about what to do. And we'll go from there. Thank you so much. And you are excused, guys.
Thank you,
Judge.
Your Honor.
And bye, everyone.
Thank you. Okay, busy day. Let's see. Our next one is Meredith Ann Peel here? In Ray, Meredith Ann Peel.
Your Honor, we're here representing Mr. Peel.
Okay. Who is that, Miss Downs?
Yes, how are you this morning, Judge?
Good. I usually do this in a breakout room. Would you guys kind of prefer if I did that?
Yes, please.
Okay, let me go ahead and take care of that.
Judge, I have student attorney Alyssa Alfaro.
Where is she?
She, raise your hand, Alyssa, so the judge can see you.
There you are. Okay, so I will move. Okay, so I'll go ahead and set up a breakout room for this.